Hi, everyone. Welcome to 2025 Cannabis Legislative Update. I'm Rachel Serwin, Student Ambassador of the Beverly Hills Bar Association, and I'm delighted to introduce today's speaker, Shay Gilmore. Shay Aaron Gilmore is a leading California cannabis business attorney specializing in corporate and commercial transactions across the cannabis supply chain. He advises operators and investors on regulatory, real estate, corporate, and related legal matters to protect and expand access to cannabis. Shay has been recognized among the top 20 cannabis lawyers in California by the Daily Journal and named a Northern California super lawyer by Super Lawyers magazine. So let's get started.
Thank you very much, Rachel, and for that kind introduction, and to the Beverly Hills Bar Association for this opportunity to take a look at the California cannabis laws of 2025. I published an article about the legislation that was signed by the governor, and also included a little bit about the two bills that were not signed back in October. But as is often the case in the cannabis and hemp space, developments rapidly proceeded to change from that point in time in October to now. Most critically, with some federal legislation that was signed in November to end the government shutdown. And we'll get into that later in this presentation. But I'd like to start off by just kind of calibrating your sense of where this presentation is going to proceed. And we can start with looking here at the legislative achievements, the bills that actually made it through the 2025 legislative session in California. And there are four main success stories legislatively. The first and most important of these is AB 8. This is to address what has become known as the hemp THC loophole. And we'll talk more about that later in the presentation when we get to the federal change. And AB 8 would or will, when it comes fully online in 2028, integrate into the regulated cannabis supply chain all of these other products derived from hemp. Another bill that made it through in time to reverse after only a 3 month duration is AB 564, sponsored by Assemblymember Haney. And yeah, folks may know that the cannabis excise tax in California, among the highest in the country, was set to go even higher, and in fact did go higher from July 1st through October 1st. And thanks to this legislation, it was reduced back down to where it started the year at 15% of gross receipts. Now, this is, I think, important to recognize is again only a temporary fix and extends through May of 2028. So we'll be back to square one in a little over 2 years here because we're coming up on 2026 in a matter of weeks. Another bill is this online marketplaces bill that Senator Weiner uh, put through the legislature. I actually testified in connection with that bill for a client, and we can talk about that when we get to it. And the last bill, just to set the stage, is an expansion and expedition of controlled substances research, AB 1103. We can talk about that in a little bit more detail. But first, Next slide. We'll talk about the comprehensive overhaul for hemp that's under AB 8. So you could call AB 8 the crown jewel of this legislative session. It's pretty complex, but the basic overarching idea is that the bill recognizes that the current federal hemp regulations, and this, will be changed, as you'll hear later in the program, come November of next year. They create a loophole for products with a less than 0.3% Delta 9 THC concentration. So what this loophole created was a $24 billion unregulated market for things like Delta 8, Delta 10, THCA, HHC. These are all variants on the THC molecule that the Delta 9 variation of which is specifically mentioned in the 2018 Farm Bill, and these others are not. So these are products that often have higher potency than regulated cannabis. And so AB 8 says starting January 1 of 2028, if the product has concentrated cannabinoid and intoxicating effects, it must be licensed, just like the regulated cannabis supply chain is. And there's a 3-year phase-in time to give industry the time to comply, but I think we haven't seen the regulations completely adopted, so we still have some uncertainty that's out there. One thing to keep in mind about AB 8 is that CBD isolate and CBN isolate are carved out of this legislation. So they proceed under the regular CDPH Sherman Act for cosmetics, food, and drug in California that other non-cannabis products would proceed under. There's also a ban on synthetics and just to bring all of this around, it would be fully implemented starting in January of 2028. Next slide. So, just to keep in mind that AB 8 has expanded enforcement provisions. State and local agencies are now going to be able to seize and quarantine non-compliant products, not just issue citations. There's a track and trace integration that's critical here, right? Because right now, none of these products are part of Metric, and now they will be tracked and traced through Metric, just like the regular cannabis supply chain, meaning serialized packaging, chain of custody documentation, real-time inventory visibility, all that kind of good stuff. Another thing to keep in mind is the tax benefit here for the regulator. This is an expansion of the tax base. Clearly, if you're bringing all these products into the regulated market, that 15% uh, excise tax will apply. And so that expansion of the tax base will lift revenues for the regulator. Um, I think one thing to what kind of grapple with here is that this is more than just a regulation bill. It's a regulation with teeth bill, and so we're going to start to see like expanded powers for enforcement that are really going to be driven at shutting down this whole however many billion-dollar a year industry that's out there. Next slide. SB 378 for digital marketplaces for hemp and cannabis. Um, I think It is groundbreaking because it targets platforms for user-generated illicit cannabis sales. It's unusual because platforms typically get Section 230 immunity. But this bill creates for any platform that hosts listings the obligation to either prohibit cannabis and hemp ads or verify the licensing is valid before allowing the ads. So there's a substantially contribute standard that's broad, treble damages, civil liability. This is going to force platforms to get more serious about the advertising out there and to really require that the platforms are dealing only within the licensed supply chain and not outside of it. I testified on behalf of a group of hemp, low dose THC, non-intoxicating hemp product manufacturers in connection with this bill. I can tell you that, like during the hearing, it was before the Assembly Judiciary Committee in Sacramento, that the legislators were really interested in the tech aspects of this bill, and kind of really didn't focus a ton of their attention on the obvious impact that this bill will have on the THC hemp-derived THC supply chains. Um, that said, there's AB 8 that also we covered that intersects very conveniently along with this one to further restrict that supply chain out of existence. So, next slide. So, I think briefly want to mention the temporary tax relief. It is temporary, it is relief, but it's really status quo, right? Because it's just a return to where we were started at the year beginning of 2025. So nothing has gotten worse. We've just managed to keep it from getting worse. The fact of the matter is the excise tax is already too high. And we know that because of the continued prevalence of the illicit market, which pays no excise tax, while the regulated market continues to bear 15%, stretching up to 19% for 3 months this year. So temporary, and we're really kind of going to be back where we started if we don't get a long-term solution in place. Next slide. So AB 1103, this was to remove bureaucratic barriers to federally approved research on controlled substances like cannabis, psilocybin, MDMA. So the problem that was in place before this legislation got signed is that the California Research Advisory Panel was bottlenecked between formal meetings. It couldn't act, and so there were like 6 to 12 month delays for research approvals. And this meant that University of California researchers were losing federal grants because they couldn't get state approval in time to spend the money on their research. AB 1103 solves this problem by allowing faster meetings with smaller expert groups, temporary exemptions from the Open Meetings Act until 2028 for sensitive discussions about intellectual property and trade secrets, and asynchronous consultations. So email, right? Like getting forward movement without actually having in-person conversations, ones that can be conducted over email. The focus areas for this research are substance abuse disorder treatment, mental health, trauma, PTSD therapy, research that could make a California leadership position for this area of study in medicine. Um, uh, it's been signed into law by the governor and goes into effect immediately. Next slide. So I just wanted to briefly mention the couple of bills that did not make it through. These are in my article from October. I feel like because they made it all the way through the legislative process up to the governor's desk, that they could surface again, maybe under a different governor. And so just want to, I think, flag them. The first one of these is AB 632. It would allow cities and counties to record property liens for unpaid fines related to illegal cannabis grows. Um, so, I mean, essentially, uh, you would be given under this bill as a local government a clean, like form driven shot at grabbing a lien on the property where the illegal activity is taking place. Right now, the current process obviously allows for a lot more process for the defendant, and this bill would seek to limit that. Governor de declined to sign it, vetoing it, saying that existing law already provides lien authority through normal legal process. It's true, and that this one would skip judicial review and be violative of due process. I think the local jurisdictions would argue that that process has been shown to only benefit the illegal grows and not the community trying to actually enforce um, compliance. And then AB 1332 was vetoed. This was to allow direct-to-patient shipping for rare and specialized medical cannabis deliveries. Um, the governor thought that the implementation cost and administrative burden outweighed the narrow benefits here, but he left the door open for future access-focused reforms. So we may see maybe a scaled down version of this bill later on. Uh, Time will tell. Next slide. So, like I mentioned, my article about the California legislative session and the bills that we just discussed, including the ones that were vetoed, um, I got published in October. And what a difference 60 days can make in the cannabis and hemp space. And, really the most critical of these developments is I mean, you can, definitely put the flashing red emoji up there on this one because this is the most significant change in cannabis and hemp, certainly this year, and maybe for the, last uh, 6 or 7. So there's a few things I want to emphasize here at the outset. November 12th, 2025 is a date that for some people will live in infamy, some people will celebrate it. But Congress passed a continuing resolution that included a rider redefining hemp. And this wasn't the focus of the bill. You might remember this was just a few weeks ago, just over a month ago, and hemp was out there, but there were other things going on as they were trying to get the government restarted. So the effective date for this redefinition of hemp is 1 year from now, November 12th, 2026. And so we're, under the 12-month co countdown right now. It's not a proposal. It's not a debate. This is not pending. This is the law. And stakeholders now have 12 months to comply with this federal law that has now been signed by the president. This affects every Delta 8, Delta 10, THC, HHC, currently, all of these products currently sold legally in the US. And 95, the industry is estimating that 95% of current hemp-derived products will be illegal on November 12th, 2026. Think about that, right? And we told you it was like billions of dollars in market. So this is a wake-up call moment. It's urgent and it's massive. Next slide. So the new federal hemp definition, this is where specific numbers matter. So the old standard under the 2018 Farm Bill was that hemp was cannabis sativa L with a less than 0.3% delta 9 THC concentration on a dry weight basis. There was no testing for total THC, and there was no restrictions on THCA, Delta 8, etc., all these crazy compounds. The new standard that has been passed and signed and will go into effect is that hemp will equal cannabis sativa L with a less than 0.3% of total THC, including THCA, on a dry weight basis, plus a less than zero point 0.4 milligram total THC per finished product container. Okay, so just to give you an idea of the size, zero point 0.4 milligrams is extremely small dose that's so small that it really does wipe out the market for anything that could possibly be intoxicating on a THC cannabinoid basis. So just keep that in mind. They've reduced the packaging size that's allowed to contain, or rather, they've reduced the amount of this to such a per package size amount that is so tiny as to be really chemically non-reactive to the endocannabinoid system in the human system. So I think it's also critical to understand here that there's the dual threshold here that it could, right, the product could pass the 0.3% dry weight test, but then fail the container limit test. For example, a gummy could have a 10% THC content, if it exceeded the point four milligram per serving of THC, then it would fail that and so be wiped off the market. So this really means that any products with these cannabinoids are going to be Schedule 1 controlled substances after November 12th, 2026, if you're looking at the market currently. I mean, 95%, it's probably higher. I think 95% is the floor for what you're going to look at um, going back to Schedule 1. And keep in mind, all these products have been off the schedule since 2018. So that's a pretty rude awakening for, rude development, I guess, for this industry. So thousands of hemp companies are going to be affected here, including ones across the country and ones based here in California. Next slide. So the California impact is coming into focus here from this federal redefinition. Remember, we talked about AB 8 and how it allows intoxicating hemp products to exist as a category through 2028 with licensing and testing requirements. But the federal law is going to make those same products Schedule 1 on November 12th, 2026, 14 months before AB 8 even comes fully online. So, you're gonna be looking at another legal impossibility, the same that we operate under really in the Delta 9 regulated supply chain, where California says you can sell these with a license, while federal laws are continuing to say that this is drug trafficking in Schedule One narcotic. So there's an interstate commerce implication that's pretty important, and the answer is that you cannot ship hemp products across state lines if they're federally legal in one state, but another state has not made them legal. So federal law preempts state law, and there is no federal law allowing interstate commerce for Schedule One substances. The reason that you have had interstate commerce up until now and up until November of 2026 is because all of these products that were designated to be hemp were off the schedule. So, of course, they could be traded, moved interstate. That is coming to an end in November of 2026. So, uh, we're kind of looking at like an enforcement issue here, I think, because we know that federal enforcement on cannabis is currently a low priority, but when Congress is explicitly redefining a product as Schedule One, we typically see, with a new, congressional piece of legislation, uh, renewed interest when agencies take on the implementation of that legislation. So we could be looking at increased enforcement. But I think that and there have been some people that have written about this out there, even that increased enforcement may not be enough to really address what is required. This space is huge, and there's no real indication that the illicit market is just gonna fold up and go home just because a bunch of legislators got together and wrote some law that means nothing to them, obviously. So I think that there is a big question mark about the enforcement aspect around this closing of the hemp loophole, and specifically here in California. And where will the DCC be? Just as a added, kind of question mark, when and if there is any federal enforcement of the closing of this loophole, will the DCC stand, in the way and protect operators? Remains to be seen. Next slide. So, like I mentioned, the dates are critical here, and November 12th, 2026, that is D-Day. And so there are specific products that are going to be affected. I think it helps to kind of break these down. Delta 8 THC, it's made from a hemp through isomerization. That word. It's a roughly $5 billion market, and it's dominant in convenience stores nationwide. Delta 10 is a similar process, but it's also widely available. THC dominant products like raw flower or concentrates with high THCA, which converts to THC when it's heated. So, I mean, kind of looking at two sides of the same coin. It's legal under THCA, legal under current hemp rules because raw THC isn't Delta 9 THC. But when the new rules come into effect, total THC of these products will exceed the 0.3%, and so they will be prohibited. Back to Schedule One, they go. HHC and THCP and other of these novel cannabinoids, they're all banned. Full spectrum products, even products labeled 1% THC, might still exceed the 0.3% total THC when you add in things like THCA, CBDA, and other cannabinoid precursors. And this, remember, we talked about this 95%, the industry estimate that we're looking at a ban on in November of next year. It comes from this fact that of the 4 billion hemp-derived cannabinoid market, only CBD isolate and CBN isolate are clearly compliant with the new rules. So, I mean, and these are, not insignificant parts of the market, but they're not big. And um, if you're a CBD isolate manufacturer, you're going to be able to uh, scoot out of this because there is a pathway for you carved out. Same thing for CBN under AB8. And we will know more after, and I'll mention, later in the presentation, the FDA comes out with its list in February. But right now, it looks like these products could it, stay within a legal regulated supply chain outside of the cannabis AB8, metric, track and trace, all that kind of stuff. Next slide. So one thing we, could uh, consider while this is happening is that there's, some congressional response and advocacy to resist what has been signed into law. Um, Nancy Mace and some bipartisan co-sponsors have introduced legislation to repeal the hemp definition. Okay. There is a strong industry coalition supporting repeal. And, I wouldn't count any of these guys out. The U.S. Hemp Authority, National Hemp Association, farm groups. Okay. They're gonna make the case in an election year. Okay, sure. Their rationale will be that the hemp industry has created over 300,000 jobs since 2018, and this will totally obliterate that. I think the repeal bill is active, but it's uncertain, and there's going to be other things taking attention, I think, other than this. So, I mean, it just is, we're looking at not just, I mean, this was passed on November 12th, and it's got a 1 year ticking time clock on it. So, you're already every minute that you spend, not repealing this bill is just a minute closer to watching it go into effect. So, um, I think you should not count on repeal before November. Next slide. So, this is, I think, where the kind of California uh, view of this space and how the California approach is going to be an intersection of the state legislation that was signed by Governor Newsom and the new federal hemp definition really comes into stark relief. So, AB8 creates a state licensing and testing framework for hemp products that goes fully effective on January 1, 2028. But the federal redefinition makes certain products Schedule 1, and these are the products that don't meet that very restrictive definition of hemp. Remember, we talked about the total THC has to be now not just Delta 9 less than 0.3% on dry weight basis, and the per serving packaging of THC has to be less than 4 milligrams of THC. That becomes effective November 12th, 2026. So, about a year, 14 months, a year and 2 months before the state framework is ready, the federal law is going to be activated. So, what happens in those 14 months? I think we can look at several options that are out there right now. Option A would be that the DEA enforces aggressively and shuts down hemp manufacturers. That would definitely be if it's Schedule 1, and there's nothing stopping them. There's nothing to prevent that from happening. Um, Option B, the DEA chooses not to enforce. They could. You could be looking at some kind of, I don't know, like new memo. I think people on this meeting might recall the Cole memo from the Obama administration that articulated the position of the Department of Justice with respect to enforcement. That was repealed by the first Trump administration Attorney General, but maybe there's a new memo out there to talk about what the DOJ enforcement priorities are. Um, there is also the congressional writer that prevents the DOJ from interfering with state legal cannabis, medicinal cannabis regimes. But keep in mind that this supply chain is outside of those regimes. So the enforcement is not statutorily under the congressional right covered the same way that state medicinal cannabis activity is. Another option would be that California sues the federal government. Uh, maybe, but I would look at probably other states to step in front of California, states like Kentucky or other large hemp, maybe Texas, to try to stop implementation of the law. And then there's a possibility that California could try to accelerate implementation of AB 8. It's possible, but it would be complex to do. And, we'll see how legislation or legislators' appetite is for that kind of thing. There's a track and trace issue. DCC cannot track products that are federally classified within on the Controlled Substances Act, and so the integration of these products is going to take some work technically. I think you can plan for federal compliance on November 12th, 2026, pretty, solidly based on, what the legislation says right now. And then also, like I mentioned, there will be FDA guidance coming in February. Next slide. Speaking of this FDA guidance that is coming to us in February of 2026. So the FDA has a role here, and it's spelled out in this legislation that the president just signed. So Congress has delegated to the FDA the task of defining what cannabinoids are, quote, naturally occurring versus synthetic. So synthetics are going to be banned and naturally occurring are not. So that distinction really matters. And the FDA is going to define that distinction. So the FDA, under the legislation that was just signed, is now required to publish guidance by February 2026 on which cannabinoids are naturally produced by cannabis sativa L, so THCA, CBDA, CBGA, etc. Which cannabinoids are similar in effects to THC, things like delta 8, delta 10, HHC, THCP. FDA, we think, is likely to call these compounds similar in effects. That's the important language, similar in effects to THC. And three, definition of a container. So, is it per serving, per package, per shipment? The zero point 0.4 milligram requirement that we talked about for total THC is per container, but container's not really defined specifically. We expect that further definition from the FDA in February. So this guidance is going to clarify what's actually getting banned because if the FDA says Delta 8, for example, is similar in effects to THC, that's a legally defensible basis for banning it. But if the FDA is vague, you might have room to argue. So what the FDA says here is really going to matter on how you look at the scope and the breadth and the depth of this ban. If they come out with language like we think, and will be consistent with legislation that's been passed, I think you're looking at seeing a long list of compounds that are similar in effects to THC. So, we're in a timeline crunch right now for this sector of this space. It's now mid-December 2025, and the FDA has 6 weeks, 6 weeks to publish guidance that will affect billions of dollars in commerce. And maybe that's not realistic. Maybe the FDA drags their feet, and I've heard from some that they're not always punctual and like adhering to their deadlines. So I think that also extends uncertainty in this space because the scope of this ban is written into the legislation to hinge on what the FDA says in this guidance, is a set of clarifications that is now currently due in February 2026. Next slide. So, what can stakeholders do now? Here's my top pieces of to-dos on the list for stakeholders. Monitor AB 8 implementation and rulemaking. So the DCC is going to be writing regulations through this next year and 2027, getting ready for the 2028 full implementation. These regulations are going to define what products actually qualify, what licensing looks like, what the testing is that's required. There'll be opportunities to provide feedback, keep in a current state of knowledge with the rulemaking that's going to proceed over the next couple of years. Track this FDA guidance. We're targeting February 2026. I think it's safe to say they won't come in before February 2026. But be looking towards what the FDA has to say, starting just within a matter of weeks from now. Um, if you are in this space or you represent clients in this space, you should be having a audit of your products against this new federal definition of hemp going on right now. You should be understanding what is it in your product portfolio that will become extinct as a legal product in November of 2026. If you are currently moving that through the stream of commerce right now, you also want to evaluate compliance costs. I mean, it is no secret that these costs are high, and that the regulated industry has borne a really crushing burden in terms of these compliance costs. Well, now these costs are coming for this whole other chain of supply that's been essentially unregulated now. So you should evaluate what your economics look like when you're now dealing with what has been previously experienced as a crushing burden for that supply chain, for the cannabis supply chain. Next slide. Oh, and one other thing I would just mention real quick, interstate commerce, you need to understand that that is coming to an end for these products that are getting redefined out of the federal d definition of hemp. So that also affects things like how much investment you're going to attract, how big you can scale, all that kind of good stuff. So key dates ahead. Obviously that November 12th, 2026, that's the law. So that federal hemp redefinition becomes effective on that date. Current hemp products out there, they pretty much, I mean, I think 95% should be like your floor of these products likely become illegal on that date. So it's a hard deadline. DEA enforcement. We don't know what it's going to look like, but it could kick in an aggressive way on that date. Do not know. After that date, um, January 1, 2028 is when 14 months later. So again, we talked about that period being a time of there's, different options that could be taken by the federal government. But after that 14-month period is over and January 2028 comes around, AB 8 will come into full implementation here in California, providing for hemp licensing, testing, track and trace. All that is going live, and only compliant products will be allowed in those retail channels. May 2028. Remember we talked about AB 564. Well, look what's happening in May 2028. The AB 564 timeline of 3 years to reduce the excise tax from 19% down to 15%, which is where it started the year. Well, that expires. And so, we're going to be having a lot of a continuation of this conversation that we just had this last legislative session on, the just kind of absurdity of having such a high excise tax on a regulated industry that is dwarfed by the illicit market, dwarfed. An illicit market that pays zero excise tax. Secondary dates to watch. Obviously, we talked about the February 2026 FDA guidance deadline, and then there's going to be rulemaking throughout 2026 and 2027. The next 3 years will be the most transformative period in hemp and cannabis regulations since 2018. So just stay tuned. Next slide. So, to kind of bring us into focus going forward, I wanted to, kind of big picture, bring all of these concepts together when, we're talking about the 2025 legislative session for California and how it is impacted by this federal redefinition of hemp. So, um, California state framework, and I think you can include absolutely AB 8, SB 378, and AB 564 that had to do with, the integration, right, and taxing and regulation of online marketing for these supply chains is all about modernizing the system that we have for cannabis and hemp regulation, integrating hemp into the licensed market, cracking down on online illicit sales, and giving a tax relief window to the legal market to give them some competitive footing to stand up to the illicit market against which they are dwarfed. Let's just not forget that. It's not even close. So at the same time that this is happening, and as keep in mind, Governor Newsom signed AB 8 before this federal law was signed by President Trump. This federal law, which comes fully online in November of 2026, is restricting the hemp definition and narrowing what products qualify, banning synthetics, and creating Schedule 1 penalties. So this is the paradox. As states are liberalizing and regulating, federal law is tightening and criminalizing. So the result is you have an unprecedentedly complex compliance situation, and you can't just follow one regulatory pathway. You've got to really look at, here in California, at both the federal guidance, really starting with the law that was passed, but then looking at the FDA clarification that's due in February, and then whatever changes we see along the way up to November of next year. On the California side, you have some rulemaking that's going to take place as we gear up for full implementation. But remember, in this time period, you are looking at a 14-month duration where products that are federally banned could be subject to DEA enforcement depending on the level of aggressiveness that they decide to take in their approach. So, I think you want to understand that this is all evolving rapidly, and if you're in this industry, you really could benefit from a regulatory strategist. And you really need to think about and advise your clients to think about how compliance missteps can mean, game over, loss of license, civil liability, criminal exposure, really, when you're talking about products that are federally illegal. So I see that there's uh, a couple of messages in the chat. I'm not sure if these are actually, no, these are not, or wait, hold on. Uh, Q&A. Aha, yes. So I'm going to turn to these real quick and see if I can get answers to these. So, how does Trump's recent executive order seeking a reclassification of marijuana as a Schedule 3 interplay with the November 2025 Congressional Act redefining hemp? That's a great question. So, really. The answer is not too much. And I actually blogged about this issue of the federal rescheduling, and I will put my I don't know if I can put my a link to my blog, but it's out there at shaygilmorelaw.com. Um, and to give you like a better formulated answer to that question, it's helpful to think about what rescheduling does, right? Because the list of what it does is a lot smaller than the list of what it doesn't do. So all it really does is it takes away a burden that is only felt by a very, small number of entities. And these are cannabis businesses that aren't allowed to take normal business deductions because of this section of the IR, Internal Revenue Code, Section 280E. Once rescheduling happens, 280E problem goes away looking forward. It does not go back retroactively. So that these cannabis companies the plant touching cannabis companies will then have the ability to take normal deductions. So with the Congressional Act redefining hemp that takes effect November of 2026, that was passed in November of 2025, you're not even talking about, I mean, these companies were already outside of the 280E problem, right? Because they were dealing in products that were off the schedule. So, right, I mean, you can, like, y yes, if they were to integrate, into the regulated cannabis supply chain that has the 280 problem that is going away, okay, yes, they would then be able to continue not having that 280E problem. But I guess the way to think about it is they've got a lot bigger problems than 280E coming down the pike for them to face. So that's kind of how they interplay. It's not, I mean, because they're already outside of that system as this hemp, derived THC loophole market, they've never really faced the 280E burden the way that the regulated state legal cannabis industry has. And then another question I have here is, do products you mentioned include cannabis flower? Yes. Yes. That's within the definition. Um, I just want to say thank you to the Beverly Hills Bar Association for giving us this time. If there's any other questions, please don't hesitate to pipe up in the last minute that we've got here. But I w would be remiss if I didn't mention to all the attendees that if you are interested in learning more about cannabis law and all of these things that we talked about here today, the International Cannabis Bar Association is the largest international group for lawyers practicing within this space. I'm on the board of directors, and I invite you to learn more about the International Cannabis Bar Association. I hope Beverly Hills Bar Association doesn't mind that plug. It's also a nonprofit, just like Beverly Hills. But again, I'm very gratified to the Beverly Hills Bar Association for giving me this opportunity to talk about the 2025 California legislative session and how the laws that came out of this session really have a collision course set out for them with this federal change that was signed by President Trump just over a month ago. That with some tweaks here and there by the FDA will become effective in November of 2026. So thank you again for your time and attention today. Any questions? I am at your service.
This concludes today's presentation. Thank you again, Shay, for your time educating our members, and thank you so much to our audience. Have a great day, everyone.